Hey, there you have it. Judge Harm does not allow prosecutors to bring in that last text that was between some unidentified associate of the defendant talking about an alleged crime that was going to be taking place, a robbery of sorts. Judge Harm said no, hearsay not coming in. Does allow the other two between he and his grandfather. Joining me now to discuss this case by Skype is criminal defense attorney Geoffrey Nathan. Geoffrey, good to see you. First question to you, the coronavirus and its effect on the legal system. It is unfolding by the hour across the country. There are courthouses that are just different degrees shutting down. They're using video conferences. Trials, jury trials are being halted. In this case, the judge is saying we're going to move forward. We're going to keep going here, but the defense wants to. First of all, the defense would like this to be delayed. Second of all, they want the judge to inquire with this jury as soon as they come in this morning to see where their heads are. How much of a concern is this? Because if you do have a juror that is very worried about the coronavirus and is stockpiling toilet paper, they may not have their head in the game here.
Well, we're going to go and work on the premise that jurors, once they're sitting in their chair, have put a national, international pandemic behind them, and that they're going to focus and concentrate on the evidence. Because remember, they swear when they're seated in those chairs, they swear to the court that they will put all external influences behind them. So the judges make sure that they admonish the jurors to do just that, and bearing in mind there is someone's life at stake here. So I'm sure that the toilet paper is going to take a second seat, literally speaking, when it comes to the life or death of this criminal defendant.
What about the case itself? As it's moving through, there's a scheduling issue at the end of this week in that the following week is dark. This is a death case. The odds of the state finishing, the defense going, if the jury does come back guilty during the guilt phase, would it be okay to do the penalty phase after that week off? Would that make sense to you? That probably would be the way this would go, if indeed there would be a penalty phase needed.
Indeed, there's nothing untoward with having a pause in the proceedings and then re-impaneling and hearing the death penalty phase at a later time. That's not that terribly unusual in this sense that you don't have to go right from the verdict of guilt immediately into the death penalty phase. That being said, the state of Florida is going to be under the gun to close this matter out, and they're going to start offering sweetheart deals to induce the defendant to plead guilty for something less than the death penalty vis-a-vis. They may even, I bet, give him a number on the sentence that he could aspire to, that he could serve a 25-year sentence and then get out and have something, a life for himself. So I think that's what Florida's probably doing in the back seat of this thing here.
You think they'll wait for the guilt phase to conclude and then offer a deal, or you'll think that there could be a deal in the works this week?
Oh yeah. I mean, when you brought up the courthouse closures, I mean, where I'm in Massachusetts, we're shutting down Tuesday, Wednesday, statewide. I don't know for what, just 2 days. The federal courts in the United States have stopped jury trials in their entirety. So, the only proceedings that are going to be heard in the United States are these kinds of trials that we're seeing right now. This very important trial on the issue of text messages and what is hearsay and what is totem pole hearsay. And these are critical legal issues. But in the meanwhile, the state has to protect those jurors that are either being shuttled or picked up by sheriffs, brought to court. I don't know how they're getting to court. That's always, by the way, an issue. So here we have the health and safety of the entire state at issue, and Florida is going to want to punish this defendant, but they don't want to have a mistrial. And what they're risking with that pause that you're bringing up is the defense saying, hey, wait a minute, we were so prejudiced by this that we couldn't get a fair trial. So yes, I mean, in many of your more crowded urban populations, we wouldn't even be having this trial. The defendant would have already been offered, probably a double-digit number, 20 years in the slammer, and if he comports himself in a measured fashion and does what he's supposed to do, he can actually be paroled after 15 years, even with a planned premeditated murder if it's their first murder. So let's just assume that it is their first murder and that they're not going to have another murder, because most people that commit murder only do it once. It isn't that unreasonable to hand out a sweetheart deal in the middle of the trial, is what I'm trying to suggest. Ed.
Right, which I think would have come up already, and it may be in the works. And frankly, the state of Florida is a little bit different. It's not Texas, but 15 years in the old slammer isn't going to cut it, I don't think, in the Warner case, just because of the state's aggressive stance on crime and punishment. I do see that Judge Harb is back on the bench. Do we want to take a break? Let's take a break first, and then we'll get you back into the courtroom right after this.